And we're back. It's a day 13. I'm losing track of what day it is, but we are here nonetheless. Break down what I thought was one of the most interesting days of this trial. We've got a lot of watch together, a lot of things to discuss today, a lot of rules to discuss and how it works when you break rules and whether or not you can actually waive rights, or are there unwaivable rights? Do they have to be knowing? Do they have to be explained properly? What does it mean that you actually understand something? Well, we are here in my office tonight because the internet is down in our area. And actually, we are on backup internet here at the office. So if there are freezes, I apologize. We will work together to make it as smooth as possible. And of course, I will answer as many questions as I possibly can. I did a little behind the scenes clip on Instagram Live. So if you want to check that out, at Tragos Law is our Instagram handle. You can check it out after this video. It's just a quick recap of the trial today. Not any clips, not any questions answered, nothing like that. Quick recap, and I gave a little behind the scenes of what my office looks like here and how the YouTube stuff is all set up. So if you guys want to check that out, feel free to do so. We will discuss so many things that happened today. But before we get that, people are saying sound is fine. I'm a little bit fuzzy. That's okay. That's just a filter. That's just a filter to make it fuzzy. But we're going to get to it. Hit that like button if you haven't already. Subscribe to the channel if you haven't. We are going to jump in and talk Daryl Brooks. We're going to talk closing arguments. We're going to talk soft sit. We're going to talk judicial determinations. We're going to talk lawful laws, admiralty law, protecting the record with slick talk, oath of office, all kinds of things. We are going to hit it on today's episode. We are actually in the process of working on our new intro, so that's going to be coming. I don't even know if it's going to be a new video, but I recorded new audio for the intro today. So without further ado, let's get to it. The day starts by Brooks saying he isn't calling any more witnesses. But he didn't say it so clearly, and instead they had to go back and forth a million times, and the judge had to ask, what about Don Woods, your mom? And instead, he just starts talking about putting in evidence of a class action lawsuit about the car that he was driving, the faulty accelerator, how it would go on its own. This is actually true. We've handled some cases with Fords that have this issue. Some police cars, actually, some squad cars have had this issue as well in the past, but his age and mileage doesn't actually fit into the class action. He also didn't own the car. So they said his mom would have been put on notice. It's way too late to discuss this as well. He had his opportunity to cross-examine the law enforcement officer about it if he wanted to, the accident reconstructionist guy. He didn't. He was talking about recalling him potentially. The judge ended up saying no. We will talk about what jury nullification is. I see a lot of people asking that. We'll get to all of that. The state agrees that the class action exists, but his car doesn't fall into it. And the judge starts to read him the colloquy about testifying. We had a lot of discussion. Rob from Law and Lumber said, just based on the fact that he's a narcissist, and a lot of you guys agree, I think he's going to testify is what everybody was saying. And very possible. I was not positive what this guy was going to do. I'm never positive what this guy is going to do. But if we think about what his MO is and how he's been acting throughout the entirety of the case, what do we think Daryl Brooks will do? Well, he is not going to put himself in a situation where the state's going to cross-examine him about all his prior crimes and tear up all of the, potentially things that just aren't true, or these lines of questioning that make no sense and none of the witnesses actually agree with. He's not going to do that because he's not dumb. At least I don't think so. Some of you guys disagree. I think he's pretty smart. And so he's not going to do that, but he also is in no way, shape, or form is he going to waive his right to testify. Is he going to clearly and knowingly waive his right to testify? He's not going to do that. So instead, what does he do? He doesn't answer questions. And remember when he said, man, Judge, I can't get a straight answer out of you. That's rich. He doesn't answer questions. He says he doesn't understand things he clearly understands. He can't hear, whatever the argument may be. He dodges, dips, ducks, and dodges a little bit more. And I could build a box for it. I just saw that post come. I could. I have plenty of boxes out there. But it really is, to me, exactly what we all should have known Darrell Brooks is going to do. Make it difficult, make it messy, make the judge make a call. And I got to be honest, she didn't wait that long this time. Thank God. We didn't have to go back and forth too much. But she explained it to him more times than was fair. And he still ends up waiving his right. At one point, I think he wanted to be sent into the other courtroom, and eventually he was. Hold on a second. And eventually he was booted to the other courtroom. And we got a lot of Bible talk today. And if you guys know me, I'm down for the Bible talk. And we're going to see some product placement today of, what Darrell Brooks is trying to put on for all of us. And we're going to start with the first primo position of the Bible, how he used it, and what his purpose is for the Bible in this clip. Whoop, this is 2 times speed, 2 times speed. Let's move it. For this, we can go to normal speed. All right. I don't know how and there we go. There is our first prominent view of the Bible. People are saying no sound. I don't know why that is. I have it set up to the USB device. Huh. That's annoying. No sound. All right. I'm working on the no sound. Don't know what the problem would be. So let's just do this. I'm trying to bring it up here on another spot. Tell me if you guys can hear the sound now.
He would forfeit his right to be present in this courtroom.
Can you hear the sound there? Still no sound. Huh. Okay. Well, we will fix the sound eventually, hopefully. But he holds the Bible up. Okay, there it is. All right, good. All right, good. We got the sound. Thank God. So he holds the Bible up. But what's really interesting, right? And we'll get to more of the Bible later. But what's really interesting is watch his eyes. You can see the whites of his eyes here as he very clearly is trying to see.
And would be taken to the neighboring courtroom.
There they are. There they are. That's what we're dealing with here. Clearly a prop. Clearly wants to cover up his face. And he couldn't make it any more obvious. And it's a prop he uses the whole day, as the judge at one point says, well, he keeps holding up a book, but he's not turning any pages. He wants to make sure everybody knows he is not listening. He takes off the headphones. He throws them. He hands them to the bailiff. He is always doing something to make sure everybody in that courtroom knows my man is not listening to the judge. He's not understanding what's going on around him. He wants to keep his appellate issues ripe. But the judge continues on, continues making her record, continues explaining what's going on. And some interesting things happen that we'll talk about later. But first, let's hear what Darrell Brooks thinks about the judge making her record. And here we go. He's finally going to put the headphones back on because he's got something to say.
Mr. Brooks, a third time for the record, he's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her? For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks' statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right,
He has clearly intimated that the audio doesn't work. He has clearly said he can't hear what's going on when he's in that other courtroom. He has clearly said that he can only hear when he is in the same courtroom as the judge. Yet he continues to ask to go to that other courtroom. So to me, he is just very clearly trying to set up an appellate issue, trying to cause, and the judge consistently today calls him out on his shenanigans. There's no doubt about it. The judge decided to actually call him on it today.
I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness.
So 15 times today, she creates this record and she says, you know, I asked him if he wanted to do this. Hold on a second. So she clearly states all the times, all the chances she's given him multiple times, cleaning up this record and making sure we all know exactly what he's doing. Okay. And anybody that's watching the trial already knows what he's doing, but she decides to make sure that he knows. She warns him no less than 5 times that he is about to forfeit his right to testify. Yet he still continues to just totally ignore her questions. And I think we can't just say that. We actually have to show you so we can listen together exactly how bad it was today, how difficult he was being, how he says, I can't hear you, so stop with that crap. Yet she gives him chance after chance after chance. He accuses her of basically practicing law without a license, all sorts of issues, all sorts of disrespect coming from Daryl Brooks. So let's get to it. And I'll put your very interesting comments and super chats up on the screen as we listen to this chunk together. It's about, I think it's 5 or 10 minutes that we'll listen to here.
I believe that he is feigning his inability to hear and that he's done so throughout.
Oh yeah, this is where she basically calls him a liar. That he's, you know, overblowing, over-exaggerating his ability to hear and all sorts of stuff. She goes off on him today. She's like, you know what? Enough is enough. The jury's out. The record needs to be clear. Let's talk about exactly what Daryl Brooks is doing, just in case anybody thinks he doesn't understand what's going on or he's not waiving his rights knowingly or I'm taking rights from him. Let's make everything clear right now on the record, which is exactly what she should do. She crushed today, in my opinion.
This case, there's absolutely no indication he puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio are simply false. So Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said, I can't hear you at all. I said, I have trouble hearing you when I'm over here. That's what I said. So I would appreciate if you would make the record clear.
Still not true, Mr. Brooks. Still not true. And again, we've talked about this many times throughout this trial. You can't out-lawyer a lawyer and a judge. You can't present evidence better than them if you're a layperson for the most part. Some people probably could if they're just naturally gifted. But for the most part, the technicalities, the proof, what's admissible, what's not, how we put things on the record. And you'll see later how the judge does this and the state attorney's office does this and how they make sure that it is very clear in black and white in ink when the appellate court inevitably reads this record, how he could absolutely hear in that courtroom.
Incorrect.
Clearly, he heard me say that for him to make that distinguishing statement.
I'm sitting right here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can.
Max Drummer, I actually thought the same thing, which was funny when he held it up, that, oh, it's right side up.
Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
No. Have you made a decision to tell
I will
me-
ask you again, sir. Have you made a decision to testify in this case?
Have you made a decision to address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me?
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no, and that he is not going to testify. So once again, I am.
You have no choice as a judge but to do this. Okay. It may seem unfair if you started with, well, if you don't answer, I'm going to take that as a no. There are actually laws and certain discovery rules, like a request for admission. If you don't admit it, it's deemed a denial. If you don't deny it, it's deemed, if you don't deny it, it's deemed an admission. So you have to actually answer it. You can't just refuse to answer certain questions. And that's in a lot of cases, in a lot of different scenarios. She gave him plenty of time to discuss it. Eventually, when he was not going to give her a yes or no answer, she had to make it clear. If you don't say yes or no, that's a no, because obviously you can't force him to take the stand. But you can say you're forfeiting your right to testify, which is where she eventually got.
Unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case? Yes, you have been. Sir, do you want to?
How long have I been unmuted?
Sir, do you want to testify in this case?
When I had the headphones on just a minute ago, you said you was muted. So we have.
No appellate court is going to feel bad for him or like his rights were trampled on when she gave him 15 tries and he decides to very obviously ignore her saying, do you want to testify in this case? And he says, you're going to mute me? You're going to mute me again? Well, I want to talk about subject matter jurisdiction. They're not going to feel bad for him. And that's why I think she keeps putting it on the record as well that he's a sovereign citizen, because maybe they wouldn't know that just by reading the record, but they're going to know it because she says it a bunch of times.
Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do you want to?
Because I haven't heard nothing that you asked. So how you going to ask me something and then just answer for me?
Mr. Brooks, do you want to testify? All right, I'm going to answer. I'm going to mute him again. Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial, his repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone, he has yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on valence, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy.
She can't possibly give him any more chances. She literally cannot possibly give him any more chances. Last night, that could be true. KWNY Upstate, Mr. Brooks is 10 times worse than when I had to discipline my son when he was 3 years old. My son is 6 years old. And not to put Mav on blast, love him, my favorite dude in the whole world. Literally just tonight, I'm like, if you don't stop, you will go to bed. And I hate when he goes to bed early because I only get a couple hours with him every night. And guess what? He didn't stop. So we had to go to bed. And you know what we did? We sat in his bed while he was going to sleep after we said our prayers. And we said, you have got to learn self-control. Because when you refuse to do the right thing and you know what the consequences are going to be, those consequences are going to come and you're not going to like them. That is something that Daryl Brooks never, ever, ever learned and still hasn't learned through this trial. But the judge is now putting her foot down. It's over for him. And I have somebody asking, Gary, can the judge shut down his closing argument if he gets out of hand? I expect him to go scorched earth tomorrow. I agree with you. And absolutely, yes, the judge can shut down his closing argument. The number one most protected right that you have as a criminal defendant is your right to either testify on your own behalf or to remain silent. So the fact that she made that decision for him and shut him down there from all the shenanigans he was trying to pull means nothing is safe. She is not going to let him make a mockery of this court anymore. She is going to hold the line, run a tighter ship than maybe we saw for a few days there in the middle. She is not going to allow him to do the things that he threatens to do, which we'll talk about more when we watch that clip together.
With the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks'
Definitely not.
Mr. Brooks' conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
Are you aware that you're practicing a law from the bench? Is that supposed to be some kind of threat? Like, I don't understand. He says these things with such confidence and they just make no sense.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't understand what you're asking.
He is willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying.
Did you hear me say that?
Questions, sir. I didn't hear you ask me anything.
Sir?
And that just gets him muted. If you say you didn't hear me ask anything because you keep interrupting, that's just going to get you muted. It's almost like you do this, you get in trouble. You do that, you get in trouble. You do this again, guess what? You're going to get in trouble. Hopefully he starts to learn that the mute button's coming. Somebody said the judge is going to exercise her right to mute.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time. All right, then let's. Once again, Mr. Brooks is being disrespectful. He is blurting out information. He reverts back to subject matter jurisdiction. He accuses this court of not honoring its oath. He just accused me of practicing law without a license. Again, all attempts to deflect away. I'm going to mute him once again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify. And that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back, again, to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not.
So when you do that, there comes a point where the judge just says you've waived it all constructively. Maybe you didn't say it with your mouth, but you did it with your actions, because your actions can speak louder than words sometimes, and you can waive rights based on your actions. And that's exactly what he did. So he waived his right. Case is over. She gave him, like I said, 5 or 10 chances. She rests his case and sends the jury home, because they're going to read 100 pages of jury instructions tomorrow. We'll talk about timing and things like that later. But before we get there, before we even get to the discussion of the jury instructions, the judge makes a record outside the presence of the jury where she calls a bailiff in and says, "Could you hear in that other courtroom?" And he said, "Yes, I can." We could hear loud and clear. It was actually louder than this courtroom. And as if that wasn't enough, the testimony of a sworn officer, she then brings the IT guy in who testifies that he can prove with this little thing on his phone that the decibels in that room are high enough for Daryl Brooks to hear. All of this, all of these witnesses and decibels and programs to show how loud it is in there and that Daryl Brooks can, in fact, hear the judge. All of this for Daryl Brooks because he is deciding to be difficult and say he can't hear and throw his headphones off. We had to take all of this time and waste all of these resources and this energy to make sure we protect Daryl Brooks's constitutional rights. And I think that's important, and I think we have to do it. As painful as it is, and I'm not sure it's ever felt more painful to protect somebody's rights than this case. It actually is. I mean, if you think in some of the war times, representing people who fought for maybe the other side, the losing side, but very, very difficult. So then he starts to build, yes, the box fort, and we all got to see that, and it was comical. But then the judge makes the bailiffs move the box fort. And he said something like, "I heard what the hell you said, man," disrespectfully to the judge, and he just doesn't stop. But after lunch, as she does, the very fair judge that she is, he's back in the courtroom. But he immediately asks to go back in the other courtroom. And the judge does the thing that she does sometimes, which I think she gets herself into trouble when she starts trying to make up new rules to try to do what's best for him. That's what's so frustrating. She's doing these different things, trying these different things to try to do what is best and most fair to Daryl Brooks. And she says, "Don't go to the other courtroom. Fine, if you want to go to the other courtroom, then you have to answer these questions. Will you answer these questions to go to the other courtroom?" And of course, he's not going to answer those questions because he is going to do everything he can to make this difficult. And he knows that he doesn't actually have to answer questions to go to the other courtroom because he's already been over there and kicked out of this courtroom so many times. So when she tried to add that in, he knew that wasn't going to be the case and ended up going to the other courtroom without even answering those questions. So a little more insight into how miserable he was after lunch. We're going to watch a little bit of the exchange about how childish he was and how difficult he made this on the judge. And eventually he ends up back in the other courtroom where he wants to be anyways, because he wants to say he wasn't able to take part in the proceedings because he was in the other courtroom. But it literally doesn't matter if he's in the other courtroom for the entirety of this process outside the presence of the jury. And the judge knows that, which is why she's been harsher and quicker to kick him to that other courtroom and to use that mute button.
I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections noted. If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you. I'm not forcing you at this time.
So you're not holding me to 10.
Sir, I am not requiring you or forcing you to go into the other courtroom. It is a new part of the day. I thought it appropriate to have you brought here,
Why?
and only if you forfeit your right by conduct will I put you back in the other room.
So you don't address subject matter jurisdiction for the record, or you going to stay in on the record?
So immediately he goes to subject matter jurisdiction. If she says your conduct could get you to the other courtroom, well, he's going to make his conduct do that. And you're right, MVD. That's exactly what it feels like.
I'm declining to address that on the record for the reasons I've previously to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record.
Your
have to
objection
stay
is
on the
noted.
record. Can I go back in the other courtroom? Because I'm not going to do this with you.
Mr. Brooks, I do want to go over.
We don't have to.
It doesn't matter what it is. He's going to ask to do whatever the opposite is of what he thinks the judge wants him to do. Is that clear to all of you? I think it's probably clear to all of you by now. Regardless of what it is, he's trying to do the opposite. And to me, this is good for the record for appeal, because you can't be like this and then claim that it was an unfair system. When you ask to go to that other courtroom, then when she says, is that a knowing waiver? Of course, he's going to say no to that. But Very interesting.
Instructions.
I don't understand the
verdicts.
jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
That's your choice, sir.
May I please go back into the other courtroom?
You can, based upon your choice and your request, I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand you
Sorry,
asked,
I
but I feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
Based upon what kind of me asking?
Are you willing to expressly waive that right on the record right now?
I'm not going to expressively waive anything.
Are you willing to
I'm making
engage in a colloquy regarding your right to be present
I
and
do
a
not.
knowing and intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings.
And to be in the other courtroom?
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand. I'm not making a voluntary waiver of anything.
Are you willing to be, let me rephrase that. If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you're asking.
Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Well, given that he won't answer the questions directly, for now, he is to remain in this courtroom.
I'm requesting.
And
to
she's
not
trying to
be
now
in
at this
court.
point give him what he doesn't want. So now we're seeing even more of a tug of war for power. But he knows that he can get disruptive enough to where she's going to send him out.
But you won't go through, you won't answer my questions regarding that,
I
sir.
did. I told you I don't understand.
That's not answering the questions.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand? Your Honor?
All right, let me start with the jury instruction.
Don't
There
start
is
with,
one I
don't
would
start
like
with subject
to.
matter jurisdiction.
No, I declined that already, sir. I'm not going to address
Under
that
what
further.
law? Under what lawful law?
Sir,
I
please
guess
do
not
interrupt me
last
again
night.
with the topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom again.
Are you willing to engage in a discussion about that, sir? I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? I can't answer something I don't understand.
I believe you're choosing not to answer them.
You can
sir.
believe what you want to believe. I believe that you hide stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
rights
doesn't
are
matter
not
what we
emphatic,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me
It
because I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that right?
anything. Nope. I don't understand. Nope.
Then you're going to stay here. For now.
And under what lawful law? You can't force me to stay somewhere that I'm making a request not to.
CT Bourne, no. He's doing it on purpose. It's so obvious, especially when he does respond after he's taken off mute. It's clear he does understand and is listening to what's being said. He just doesn't like it. That's the difference.
You can't make me understand. You can't force me to understand what I don't understand. You can't force that.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do, and over talking you as you state that I do. I'm making a request merely to not be present for these proceedings. Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today. I haven't even been allowed to present any evidence, which is something that I stated weeks ago. Weeks. You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings, and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify in your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just they weren't correct
I understand you will
because I
disagree with
never
that.
consented to it and I never answered something.
I understand
And
you
I
did
just
See, he thinks, again, he's showing his hand here for the appellate court and for all of you worrying about an appeal, rightfully so. He's showing his hand. He did not consent. He didn't answer. He didn't understand. That's what he keeps saying because he has read the cases. He actually does understand that his waiver has to be knowing. He has to understand what's going on. He has to know what's going on. And it has to be voluntary. And he's not consenting to it. So he thinks that by saying that it's not a legitimate waiver, but that's not what the case law writes. We do not protect your rights from you making a mockery of the system and from you refusing to play by the rules that you want to hide behind. If you want to play by the rules, you can make your arguments, you can do your thing, you can tell the jury your story, and if they believe it, they believe it. And if they rule in favor of you, they rule in favor of you. We just had to see it in the Nicholas Cruz penalty phase trial. They play by the rules. It's what happens sometimes. Every juror had to agree, and they didn't. But he's not playing by the rules, and it comes back to bite you. It never works for the sovereign citizens. Thank you, Dana. And yes, we're almost up to 11,000 people in here now. So hopefully we're getting like more likes on every video. It's like a little bit more likes, a little bit more, a little bit more. Let's see if we can get a little more. I think we had like 13,000 or something on Saturday night's video. Let's see if we can get that. All right, I am going to take a minute here. Let's take this off the screen. Let's answer some questions. We've got a couple more clips and a couple more things to recap and talk about from the day today because it was very interesting. Even after, the evidence was over and they sent the jury home, a lot of this happened after that, which is always very interesting. What happens is from Terry. What happens if DB starts with his nonsensical rants during his closing argument? The judge has made it clear she will shut it down. And we're going to talk about some of the things specifically he tipped his hat that he would be doing. One of them is jury nullification, like Evan said. We will talk about what jury nullification is in a little bit. Smith, wish you could watch this live with us tomorrow. Well, Smith, it's funny you say that. Let me know in the comments and the live chat. If you're in the rewatch crew, let me know in the comments. But if you're here now, let me know if you want me to stream Daryl Brooks's closing argument live tomorrow by posting live in the comments and like the video. If we get over 13,000 likes on this video, I will stream it live. If we break that record that we had on Saturday, as long as my deposition's over. I do have a deposition, a real deposition and a real case that I have tomorrow afternoon. I think it's at 3 o'clock or 4 o'clock. It's either at 3 or 4 o'clock. So either before or after that deposition, if at all possible, I will live stream Daryl Brooks's closing argument if we can get these likes and comments to go wild on this video. A. O'Connor, he didn't understand how hard the end is going to be. While you can be arrogant about your abilities, it takes a lot of education and you gain a ton of intricate and refined persuasive communication during an internship. You learn a lot throughout your years of college and law school and practicing and learning under a mentor. So he didn't do any of that. So he's using his God-given abilities basically, and he does have some, but not enough to win this battle. Azam, there are cases they mentioned like Illinois v. Allen, State v. Anthony during trials. How are these cases chosen to be referenced? So they're chosen because they deal with the same specific issues we're dealing with in this case. Unruly defendants, sovereign citizens, what judges can actually do to stop a defendant that is running amok in a courtroom. They can gag them. They can send them to another courtroom. They can hold them in contempt. We've heard about these cases and they're chosen because they specifically apply to this factual scenario. MVD, what is the protocol for judges, rightfully so in my mind, to later call in the bailiff and the IT crew to call out the I can't hear BS? If they feel like they need to put something on the record that the defendant is clearly lying, or they feel like they need to prove right now in the best way that they can. So it's not just a he said, she said between the defendant and the judge. Marty Ferguson, especially because the judge isn't also in that other courtroom. The vehicle issue and the charges, can you explain that, please? It was so confusing. I'm not sure exactly what you referenced by this, but if you're talking about the dangerous instrumentality, he is arguing it wasn't a dangerous weapon because he's thinking it has to be a gun or a knife or something like that. But it is absolutely, evidently clear that a vehicle is absolutely a dangerous instrumentality throughout the country. Timothy Lord, I really appreciate that the judge decided to give a time limit for closing. Very smart. Yes. And the state said they could do it in 30 to 45 minutes. The judge wasn't going to force that because usually longer trials, you give a little longer for closing. We usually reserve 90 minutes, even though we don't use it all in a trial that's going to be a week or two. But they almost always in every trial limit the closing argument. They try to base it on how much evidence comes in. But that's not unusual to do that. But I agree, it was smart. ER Nurse, you got a shout out in Law and Crime today. I grabbed the screenshot of it. Awesome. Send it to me on Instagram. That's always fun. I appreciate everyone that shouts me out and everybody that came here for the recap and discussion and reaction post Law and Crime stream. That's awesome. Happy to have you here. Kat Yarb, question. He decided to represent himself. So when he doesn't understand, yeah, sorry, you're the lawyer. Isn't that the point? Is that a point for appeal? Absolutely not, especially if you go back and watch when he waived his right to counsel. Cindy T, feel like I need popcorn for tomorrow. Feel he will object continuously during DA closing, and he's going to go wild in his closing, I think, too. Lydia M, question, will he be able to receive payment for the rights for the movie about this trial, or will it to his daughter or grandchild? No, can't make money off a criminal conviction. In most states, at least, can't hear. Casey Hunter, a pure example of someone mimicking what they think is smart versus actually being intelligent. Daryl Brooks, that's a good point. Question, putting the headset on is for him to speak to her. He can hear her through the room speakers, right? So the headset is just for looks, in my opinion. It's just a facade. He doesn't need the headset to speak to her, nor does he need it to hear her. The bailiff doesn't have a headset. The bailiff can hear everything they're saying. That's what the point of was the IT guy and the bailiff saying, I could hear you loud and clear. He has a microphone, the judge, and we can all hear him through. He doesn't need the headset for that either. He has the headset because he told the judge he's hard of hearing. Leslie Grillo, can he cry during closing argument as he did during opening? I heard the judge say he can't play with jurors' emotions during closing. You can't ask the jurors to feel bad for you. You can't ask them for sympathy. Crying during a closing, she may take a break, but it's not necessarily the same thing as asking for jury nullification or something like that. Sandy R., the judge is a rock star. I'm in awe of her patience. This may have worked with some judges, and a lot of you have been saying that. A lot of you have been saying that. The judge did a great job today. I agree. Quitcher, how much longer has this case run, and how much more has this cost permitting his shenanigans so far? It's really been a disgrace to the victims. I think this case would have taken, maybe a day or two less without his shenanigans. The judge has kept it moving, and the state has kept it moving as well. Jules O, thanks for this coverage. I'm happy the judge finally put her foot down and kept him not controlling all of the court. The forts were funny, sad because of the lives lost, and he made a mockery of. Absolutely sad and horrible how he is handling this situation. Neeked, what do you think happens? What do you think will happen if DB acts up during sentencing, even in the other courtroom? Just like this, he's going to be latched to a table. I don't think he's going to be able to do much. All right, let's pull the video back up because we have a little more to watch together.
To address. You are unmuted. I am.
I just told you, I'm not.
See, he can clearly hear her.
I say even matters at this point. I'm just going to tell the jury what they need to know. I'm just going to tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're going to be based on whatever I base them on.
They're going to be based on whatever I base them on. That's not how it works, sir. It's not how closing arguments work, but that's what a lot of clients want. This is giving you I know he is a wild one, right? But a lot of clients, when they have their day in court, it's a big deal to them. Their life is on the line, or a case that has severely affected their life in a personal injury case where they lost a limb or lost a loved one or something like that. It starts doing things to your mind where you really think you're just going to do whatever you want because it's your day in court. And when you don't have a lawyer advising you, or you're not listening to a lawyer like him, this is how it gets here.
Well, I trust the state will object when appropriate,
Well,
if appropriate.
There's a whole lot of objection here because I'm going to tell the truth. You haven't allowed, you just been making all the decisions for me. Even though I told you repeatedly that I don't understand, you still make decisions based on my behalf without my consent. Without me, I'm telling you I don't understand, and you still make a decision determining my life.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy,
If it ain't-
civility, the rules of evidence, and
don't try to come
the
with
rules
those
of
slick
procedure?
words. Don't try to come with those slick words and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You've
preserve the integrity.
been slick. You've been slick.
I'm going to mute you, sir, since what you are saying is not
You've been slick. The judge has been slick. That's what he's saying.
productive. It is not courteous. It is disrespectful.
I
I need to go
I don't
over
care
these.
what you think.
All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the alternates, I do think it is important to keep the alternates who in a secure location.
So now they get into a little bit about, I don't have the timestamp where he specifically said jury nullification. If you guys want to send me that timestamp, we can watch when he says he's going to ask for jury nullification. I see Vita put that up there if anybody wants to send that to me. But he did say he's going to, jury nullification, break the golden rule, do whatever he wants in closing. You can absolutely see that coming from Daryl Brooks. Rachel, MCG, Peter, has this ever happened before? This is insane. Similar type things, but I have never seen one to this level. Platypus 7, you said the appellate court is going to read the record. Does that mean they don't actually watch videos? No, they usually read portions of the record, but we haven't had a lot of precedent where these trials are being recorded and published and so easily accessible for literally free. Like if we had to pay for all this, it'd be so expensive for defense attorneys or public defenders. But I think that it's possible that some of this video may be part of the record, and maybe that'll change the way we do appeals, which would be really, really interesting. The judge talks about keeping the alternates in a secure location. The jurors will be sequestered, which is interesting, and I think could make them go even quicker. Picking an alternates names out of a hat, just like the Rittenhouse trial. And then she gets into how long these jury instructions are going to be and how long the day is going to be. They weren't sure if we were going to get to closings tomorrow, but at the end of the day, she said that she has about 73 pages to read prior to closing arguments, which will only take 2 or 3 hours. So closing arguments are probably going to be tomorrow afternoon, hopefully early in the afternoon. And then we're going to see if we can get the closing arguments. Daryl Brooks also refused to give his closing argument tomorrow. So we'll see if that happens. And it's going to be really interesting to see what the timing actually lines up to be. And if this case gets to the jury, because then she's got another 30-something pages to read post closing arguments. Imagine how miserable that would be. She's got to sit up there and read 100 pages out loud to the jury. That is miserable, in my opinion. All right. Now let's hear a little bit more about the end of the day when they talk about the Bible and things like that. It's very, very interesting. Oh, right before this, the judge ends up saying that she's available because they talk about sentencing and when they're going to do sentencing. And it's she wants to give the victims an opportunity to come and speak during sentencing, as she should. She's like, I've got all week. And I think she said even Monday, and then I'm out the rest of the week. Where do we think she's going? Put your best guess as to where the judge is going next week, hopefully on vacation. But let me know what you think she's going to be doing after 3 or 4 weeks of this.
Then starting their deliberations in the morning, if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which is 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury and to highlight the important points.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for your any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying book. I'm looking at the Bible. Thank you. It's not just a book. It's the book.
He says, you keep saying I'm looking at a book. It's not just a book. It's the Bible. So it's the book. So I'd appreciate if you stop just calling it an a book. And what does the judge say?
Can't disagree with you there, sir.
Can't disagree with you there, sir.
How many people actually live by it, though? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then you'll forfeit your right to give one, sir, because as
you can't force me. You can't force me not. What type of court is this where you can say you're going to force somebody not to be able to give a closing argument? How is that lawful?
Sir, if you choose not to give one,
How's that lawful law?
Have you ever had
Sir,
somebody do that
if
to you
you
when
choose-
you're talking? It's like literally nothing more annoying.
not to
Damn,
give
good
one
God.
you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
You didn't even let me get my sentence out.
You always want to make a incorrect record. Go ahead, make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. If it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That'll be Wednesday morning. But now that I've really kind of laid that out and thought about the break, I will.
Somebody just sent me this. I have a feeling you won't even make a closing argument. Class act beauty, class act booty. I'm sure I'm going to hear that one again. Yeah, that's possible. Just like with testifying, it's possible. But I think eventually he will, because it's a little different than actually taking the stand. We are over 12,000. I think we got close to 13,000 on Saturday, but we didn't actually hit it. So we'll see if we hit that tonight. That'd be cool. Heather said jury nullification is a 552. Looky there. We're almost at jury nullification. All right. So we're about to hear it right now.
Will have for closing arguments with even my 107 pages. We can get this done tomorrow. And so that's my expectation. So Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush your judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
So then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know. This is the truth. That they have the power. They have the power to nullify laws.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir.
So, all right, let's get into it here for a second. Yes, thank you guys so much. Thank you, Evan. Thank you, everybody that popped in with the jury nullification. I knew that you would be able to do it, and you'd much rather probably do it yourself than have me stop the stream and freeze for a second and discuss it. But let's talk a little bit about jury nullification after I send this text real quick. Never mind. Okay, let's talk about jury nullification real quick. And then we'll finish watching the video, and then I will blow through some questions because we can't seem to ever get it within an hour when we're talking about Darrell Brooks. Jury nullification, where he just said it, have them nullify the laws of the state of Wisconsin. Jury nullification, everything we do in jury selection is, will you follow the law? Whether you agree with it or not. If you will not follow the law, meaning if you will nullify, if you will disregard the law and decide it based on something else. We even give examples like if you feel sorry for the defendant, if you think that the state's too powerful, if you don't like cops and you're going to just do something else other than follow the law, you literally cannot be on this jury. So every jury has to swear under oath in voir dire that they are not going to nullify the law. Instead, they are going to follow the law. Jury nullification is disregarding the law and making a decision that is contrary to Wisconsin law, which is what this case is under. So asking the jury to violate their oath is totally inappropriate. It's actionable. The response from the judge would be, and I'm sure there's questions which we'll go through them. The response from the judge would be a judicial instruction to the jury that they cannot do that. It would be wrong for them to do that. They are not allowed to disregard the law. Instead, they have to follow the law. Now, Why is this a thing? Well, some criminal defense lawyers and some prosecutors, sometimes just lawyers in general, will make arguments or make little references or want the jury to infer certain things that makes them go with jury nullification. They don't say it outright. Nobody would ever say it outright, but it has absolutely happened and people have won cases with it. Now, let me give you an example of one that you might agree with and that happened a ton. And when I was in the state attorney's office, I tried a possession of marijuana case, if you can believe it. It's basically like hazing. They're like, good luck with this. Like, why did the cop even arrest this person for having some marijuana? It was about 10 years ago. So it wasn't as, legal everywhere as it is now. But in jury selection, I asked the jury, how many of you think that possession of marijuana or smoking weed should be legal? And I swear every single potential juror raised their hand. We end up going to trial. We come to a plea agreement in the middle of the trial, so it didn't go to the verdict, thank God. But I firmly believe that jury would have nullified that law and not convicted this guy of having marijuana or possession of marijuana, because they just don't believe you should get punished for that, because they just don't believe it should be illegal. They are disregarding the laws of the state. So while I don't think it would actually happen here, I don't think I worry, but that would just be a dark stain on our legal system to have defendants making that argument. That is the difficulty. That's why it's such a big deal. That's why the judge doesn't want it to happen. Let's listen in a little bit more, about 5 more minutes here of this clip, and then we'll get to the rest of the questions. Whoops. She said, you have absolutely no right to raise that when speaking about jury nullification.
I can raise what I want to raise.
No, you actually
So
can't.
you had to get jury instructions at the last minute. Then you should have never approved them from the get-go, because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your homework.
Exactly.
I don't care what you're talking about. I'm going to let them know that they can nullify even though they don't agree with you, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning, he may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here. And I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented. And those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there's an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who makes
This is important for anybody that wants to pop on and watch the verdict together or talk about the verdict together. Again, timing is going to be an issue because I do have full stuff all week, but you know how we do. We will try to do it. If worse comes to worse, we'll do it that night, recap the verdict and react to it. But let's listen to what she's going to say so you can know when it's an event, when it's announced, what to expect.
Still be watching the proceedings remotely. There may be news media, in fact, that may want to cover the verdicts, and that this jury will take some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I'm contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think some of it will depend on how, is it late at night? Is it during the day? You know, are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider kind of, you know, the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that.
So before we get to their thoughts on that, let's answer a few more questions. Melinda, do you think he'll do it and be stopped? I think he's going to be stopped during his closing arguments. Yes. A couple people ask, can the appeal judge review the original trial video? There's somebody else that said this. Nisha, can appellate courts watch the court video? I'm sure they could. Usually we provide, as the lawyers, the documents, the argument, the exhibits to the appellate court. So maybe they'll include the video on a USB drive or a link, really. That's how easy it could be. That would be really interesting. Tickled Pink Music, do you think the state provided enough evidence for the guilty verdicts? They purposely didn't put them on the stand. I think they did for most of the guilty verdicts. I think intent is the only thing. The intentional homicide versus the lesser included will be the more interesting thing to see what happens there. Jilly Bear, will this case be used in law schools? Will this case be used in law schools for years to come? It should be. If so, what different ways could it be used? I've never seen anything like this trial ever. Thanks. It won't be because the sovereign citizen stuff has been played out. It's been litigated. It's really not something new, even though we're watching the whole thing for what seems like the first time and actually seeing it happen in person. Max Drummer 81, jury nullification seems pretty sophisticated for a non-lawyer. Do you think someone is coaching him in some way? He's definitely getting some stuff from either a jailhouse lawyer or a SOV citizen that wants him to promote this worldview, basically. And this falls right in line. And yeah, the judge was quick on that. She goes, you understand jury nullification? You understand jury instructions perfectly fine. Caroline also thinks he will not give a closing. Lori Jean sister or Lister, did you hear her stop herself before she said sustain? No. Robo Steve, come on, dude, quit your job. We need you here. If I quit my job, I don't think I'd be nearly as valuable to all of you, right? That's why I got to keep my day job. Be kind. This community has been torn apart by this man, and he's just continually just making it worse and worse and worse and worse, throwing salt in the wounds. Jay Carr, I was called for jury duty for the DC sniper case. Thank God I didn't make it. Death penalty question, I think. It took several days, daunting task to hold that power, Jay Carr. Absolutely. But I'm glad you went. And I realized you didn't get picked and you didn't want to get picked. I'm sure nobody really wanted to get picked, but I'm glad you did your civic duty and went. I am a pit bull mom. Can you cover jury nullification? I apologize if you've already covered it. I did. I covered it in detail. It's basically disregarding the laws in place and making a decision based on something else like sympathy or, what you think is fair, regardless of what the laws are. I did it in more detail earlier if you want to rewatch. Bobby Faye, was there even a chance of a competent defense if Brooks had counsel? Somebody else asked me, what would I do if I represented Brooks? And then Shauna asked what my dad would do. We discussed this here, Bobby Faye. What would your defense strategy be if defending Brooks in this case? And my dad and I did discuss it. The only defenses are malfunction with the car. I think I would have gone with not guilty by reason of insanity. But yeah, fleeing somebody trying to hurt him, malfunction with the car, that's basically it. And speaking of malfunction with the car, Tori asked, where's Tori's? Can you talk about the Brady violation he brought up? He thinks it's exculpatory evidence that the car was part of a class action and had an accelerator problem and they didn't let him know, and that could prove his innocence, when in fact that's not true, because even with that issue, you can still hit the brake and stop the car. Shauna, he already has shown disrespect for women by slapping and punching his ex, so I wonder how this trial would have gone with a male judge. Do you have an opinion? A lot of people have asked me that. I really don't know if it would have been any different. I think he would have been very disrespectful and dismissive of a male judge as well. Nicole, when DB does his closing statement, can he basically say whatever he wants, even if it's a lie? No. And this goes right in line with what somebody else said. Dead beef, can he filibuster by making an endless closing argument? No. And the other one was, can he bring up things in closing that did not come up in the case? Where is it? Here we go. Julie, can he talk about things not previously addressed? No. It has to be based on, we hit 13,000 people viewing. That's fun. It has to be based on the evidence in the case or the law that the case has to do. He can't testify in closing. That is not allowed. Hello, Adrian. She keeps emphasizing his conduct. Is that because that is what she believes the case law supports, but not him volunteering to go there? Yes, you can either constructively waive or waive with your mouth, literally. Biochem girl, can the court require him to provide his closing statement pre-recorded? He already said he won't follow the rules of evidence, procedure, and decorum. No, they cannot require that. J. Carr, what happens if he follows through with the threat to say whatever he wants in closing? Can he be shut down? Yes, and I think he will. Southern Girl 416, DB sees her setting more boundaries and he realizes he's losing his power. He's using every tool in his toolbox to try to get it back. He ain't wrong about that. Nick Collins, have you ever seen a defendant build a fort out of evidence boxes so they can hide from a judge? No. And most judges would be even quicker than this judge to get those off the table immediately with the bailiffs there. Colin B, I feel like the I don't understand stuff shouldn't fly. When you waive public defender, it's on you to understand the game you're playing. That's why she went through that colloquy. People ask me sometimes, why do they do these colloquies? Why do they ask these million questions of the defendant when they're just going to ignore them anyways? This is why. So you can point back to that and say, we told you you weren't going to understand stuff and you still waived your right to counsel. Casey Hunter, brief explanation of Illinois v. Allen. I believe we've never used that case here, obviously, but I believe that's the one where it gives the judge the right to kick him to the other courtroom, bind and gag him, hold him in contempt, what to do with an unruly defendant, basically. Lindsay, what's been your most jaw-dropping moment? Calling the judge a liar, telling her she's slick, telling her how is she even a judge, some of it even in front of the jury. That is wild. Bobby Cat, what do you think of the mother not showing up? Do you think he would really have wanting her to get crossed? I think he decided not to call her, just like he decided not to call himself, because they have all those jailhouse phone calls recorded between him and his mom, and I don't think that would have gone well for her. CMS, how far would he have to go to be dragged out in front of the jury? It's happened before, and it absolutely can happen if he starts screaming nonsense. All right, let's watch the end here, and then we'll get to the rest of the questions.
Statement from the state on that.
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating. If you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the
The
reserve.
entire side behind the stake for victims.
Okay, and the other side,
Public.
reserved for the first 5 minutes, or is that open seating over there? Or
My
are they-
previous or my rule throughout has been 15 minutes. What I would say is any open seating, we'll open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side.
Okay.
If that's what you're asking me.
Yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So again, I don't understand nothing you just said, but
This is his new, I don't consent to being called that by that name. I don't understand, again, anything that you just said, just so you know, but I'm going to respond to everything you just said, even though I didn't understand anything you just said. That's his new thing while the jury's not here. That's for the record.
how can you deprive me of my constitutional right? How can you trample on my constitutional right? How?
Sir, you can forfeit a number of constitutional rights by
Ah.
misconduct on your
Interesting.
part.
Not if I reserve my rights. You can't make me reserve my rights to get taken from me.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
gonna
versus
reserve that.
Arkansas, State
Yeah.
versus Anthony, Illinois
they
versus
reserve that
Allen.
Did they reserve their right?
The Beneby decision, there's a host of case law, sir.
Did they reserve their right?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry.
Go ahead.
I'm
You
sorry.
do. I'm sorry. Go ahead.
I just wanted the record to reflect that at about 2:04 p.m., your clerk had provided the final version of jury instructions to both the state and to the defense.
This is also an important thing and very smart. This is the DA, so she's very experienced, obviously, knows what she's doing, is protecting the record. And she makes sure everybody knows exactly what Daryl Brooks is doing with the paperwork, the jury instructions, the verdict form are being handed to him. You cannot claim ignorance. You cannot bury your head in the sand and say that the state didn't do their job and that people trampled on your rights when you did what she's about to put on the record.
I watched on video as Deputy Whitting left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing.
include the verdicts or just the jury instructions? Okay, just the jury instructions. But thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
Were all jurors or will all jurors then be told to report with an overnight bag?
That's part of the instructions.
Okay,
Overnight.
and you're gonna make
Let
that
me
clear.
translate
Yes.
that. She said overnight bag. She meant overnight bag, I think. I'm just kidding. The Wisconsin accent. Yeah, so overnight bags, the jurors are going to be there for quite a while. They've got to buckle up and get ready to get down to business and make their decision and get some justice, hopefully, in this case. But this is interesting because it's just telling you kind of what it's like. The logistics are different when it's a sequestered jury and it's a case like this, high profile case. So we're learning a lot as we see together how it works. And people are asking, why isn't this jury sequestered? Why isn't that jury? Every jury should be sequestered. It's really hard on them. And I think we're going to see that they're going to come back rather quickly on a very serious case with a lot of counts. And I do think that, being sequestered has an effect on that.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell. I see your arms waving. I'll get you in a second. That he's provided with that as well.
All right.
And you as well.
Oh,
And
look
then
at
one
this.
final thing is the timing. And again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future?
This is interesting.
That's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet. And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes,
I don't think I need a PSI. This is a trial. This is not like a guilty plea. So, Mr. Brooks, I'll get you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
And since we're all making records to make you look bad, I think we should say for the record that one of the rights I have is to demand that the court places the evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what case law says you have a right to do exactly
She's like, okay, you want to play this game one more time before we end? What law are you referencing? Cite some case law. Tell me what the case says about that.
what you just said you have a right to do?
The Constitution, Amendment 6.
Sir, that is very general. Your
Not a
statement.
thing again.
It's vague. There's nothing
So we don't
specific
know what?
you
Vague?
have referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So-
general arguments
also-
that aren't based in fact
Yeah.
and are overgeneralizations of what the law requires as well.
Look, he's handed another piece of paper. He throws it away immediately.
Documents in this matter. Since, it might be another record of what I'm doing, since it's always a record of what I'm doing. And I also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag.
One more. Is this common law or admiralty law?
That is a military symbol. So is this a common law court or admiralty law court?
Oh,
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system.
see, that's on the record. And that's kind of important, right? Typical sovereign tactics that have been debunked in our judicial system. And that's important because that is all on the record. The the judges are going to see that. Carsto, is an appeal automatic? If yes, is he trying to push for a mistrial with all these shenanigans? Yes, he's trying to push for a mistrial. He's trying to create issues for appeal. I don't think an appeal is automatic. In this case, it wouldn't be in Florida. I'm not sure. I'm not positive in Wisconsin if it's automatic. Nancy Marsh, is he making a tacket agreement by not answering when the judge gives him these opportunities to respond. He would say she was if the roles were reversed, right? But he also says that she's the one not answering simple questions. Ashley Harris, question, do you think that somewhere down the line, a judge will be referring to Brooks v. Wisconsin in court like the judge is referring to Illinois v. Allen? I do not. But it could happen. Bobby Cat, off subject. Did you hear about Johnny Depp's new lawsuit against the Rolling Stone? I have not heard about that. Marcy C. Peter, after the way he's been throughout this trial, how do you think he will act when the jury finds him guilty? Thank you very much. I don't think he's going to be happy. I think he's going to be mumbling stuff under his breath. I think he's going to be saying, you don't know the truth. The judge, this is all rigged. I think that's how he's kind of going to act. We're going to run through as many questions as we can here. Let me take a second and pause and thank everybody for joining this stream. 13,000 plus people, the biggest stream we've had since starting the Daryl Brooks trial. Hit that like button if you haven't already. If we get over 13,000 likes, which is possible because we know at least 13,000 people are watching, we will do everything we can to live stream and watch with you tomorrow. Daryl Brooks is closing and discuss that together, react live. Somebody said in here, you should go live with Emily. She's streaming this trial live. I didn't think anybody was really into this trial. I haven't seen it. I don't know. I've been working a lot, but if she's streaming it, that would be cool. Tell her to send me the invite. I'd love to pop on with her. That'd be fun. But I'm going to answer as many questions now as I can. As I always do, I answer a lot of questions. Does anybody answer as many questions in a short amount of time as I do? I do my best to answer all of your questions. I can't always get to all of them, of course, but I will answer as many questions as I can right now until the end of the video. So hit a like if your question gets answered. Corey, is it also true that the courts can't help him with understanding the law? Semper Fi. Yes, they cannot give him legal advice. They can't explain to him what case law means. The judge can explain her ruling, but they can't coach him or give him any legal advice. Annie Lee, is the court reporter transcribing everything DB says, even when he's muted? Thanks for your amazing coverage and insight. Like and subscribe, people. I don't think so. Another person asked, Rebecca, does anybody, or is there someone in his room writing down what he says? I don't believe so, but that would be interesting. I don't know. I've never experienced this, kick him to the separate court and mute him. I don't think it would be right if it was on the record because nobody's hearing it in the room. Why are they, this is Nanner, why are they reading so much jury instruction prior to closing? Because they have to instruct the jury on ending in the case and what they're about to do after closing arguments. They have to read through all of the charges, all of the, what the law is, what they have to prove, the elements of each charge. And as you know, we have a lot of charges in this case. Dustin Hatch, given DB's behavior and high profile nature regarding this trial, would he be sent straight to segregation, solitary confinement if convicted? I have not heard them discuss this yet, so I do not know this answer. It would not surprise me. I believe he is in some kind of protective custody right now. Gary Linker, does the judge have to read all the instructions for the charges, which are the same except for the victims? Yes, and that's why it takes so long, and we will not be live streaming that part. Nishath, question, do you think this case could set precedent just by how belligerent DB has been? No, but I do think law schools could teach about it and teach about sovereign citizens. Somebody asked, is there a law school class on it? No. And the reason there's not is it's really not that prevalent unless you're going to go be a state attorney. Civil attorneys don't, like, I think about all the other areas of law, family law, bankruptcy, probate, personal injury, wills, whatever it may be. We're not really dealing with sovereign citizens that often. Do we know who will be closing for the prosecution? I believe it's going to be the DA. She's the one that talked about how she, as we all heard together, likes to do it in about 30 minutes. Dana, I'm guessing his behavior will be worse tomorrow, and he will forfeit his right to give a closing. Who goes first, DB or prosecution? Prosecution gets to go first and last because they have the burden. DB goes in the middle. Mara Chandler, who is the guy on the right of the prosecution table? He's been there the entire trial with the DA's office. Yes, either that or with local law enforcement. Just one. How long do you think it takes the jury to return a verdict? I'm saying Thursday morning tops. This is wild, dude. Yeah, I would say by Friday at the latest. Does he have any chance, Assad? Whatsoever mistrial? No, I think the judge is protecting. Well, I can't say no. He could absolutely do something totally wild in closing and create a mistrial, but usually you cannot create a mistrial for your own benefit. That is not something that can happen. Karen, will she admonish him for behavior in sentencing? I think she may. Somebody else said, how does this affect sentencing? We'll get to that when we get there. Kate, will Weinstein trial be televised? I'm not sure. I have not followed it. I think Emily Baker is following that Weinstein trial. Bitzilla, what will prison be like for him? Probably not fun. Jules O, how would they shut him down and not let him keep running his mouth? They would take him to the other courtroom and use the mute button whenever he starts talking about something. They would give a jury instruction, tell the jury, you cannot consider this. You cannot nullify the law in this case. Cannot use sympathy. House of Virgo, how do the courts define competency for self-representation? Details. There's a whole hearing on it. You can go back and watch it. The judge goes through a colloquy. Do you understand English? Can you read? Can you write? 12th grade education. Do you understand what I'm talking to you? Can you speak? Can you listen? Things like that. It's really not the highest bar, if I'm being honest. Azam, if I remember correctly, he said no weapon, no case. What does that mean? He thinks you have to have like a gun or a knife or some weapon like that. Brianna, can jurors talk during deliberation about the case? During deliberation, yes, not before, and not like now when they're home with their families. Oreo Lovebug, if he says he is not going to give a closing, can the judge just accept it without talking to him into giving one? She's probably going to try to do a colloquy as she should, but he can waive his right to a closing, either with his actions or with his words. KWNY Upstate, if he threw things to assault the jury, could they force a mistrial since the victims of violence cannot impartially decide case against their attacker? Potentially, but again, the law does not usually give an out to the defendant. So the state and the judge could say, well, I think we're just going to keep going, but he could try to create a mistrial by totally acting wild, but they're not going to let him get close to the jury. They're not going to let him pick up anything. He's still going to be shackled to the table when he gives his closing argument. He's not going to walk freely. Angel, love the channel. Thank you. Do you believe the I don't understand argument sets Brooks up for a favorable appeal? Absolutely not. Southern Girl, will this judge be the sentencing judge? Will his behavior, here it is, in the courtroom have any impact on sentencing? Yes, she will. And how could it not? How could it not? BB, your dad must be so proud of you. It's nice to see a nice family. Thanks. Thank you. Melanie, what do you think about them taking out the instructions regarding his right to testify? I didn't hear that they took those out. They have to read that you can't hold that against him. Ugh, he is insufferable, Cat Yarb. Yes, he is. It is brutal. Kermi Tequila. Watch 20 plus hours of the trial, and this man is clearly attempting to catch this court/judge up so he can claim mistrial. Viva is amazing too. Yes. Crumb. Look forward to seeing Brooks using the Chewbacca defense in closing arguments. Yankees need not apply. Can the court just bound and gag him, please? She can, but she's chosen not to. Emily is in the chat, Peter. I don't know if Emily has ever been in the chat before, so that's fun. I unfortunately can't see the chat because I'm doing my best to answer as many questions as possible here, but that's awesome, Emily. Thanks for being in the chat. BC, is there at a least amount of time for the jury to deliberate? They have to at least fill out the paperwork. If they came back in 2 seconds, the judge would probably be like, maybe you should go back and make sure you actually read through the charges and things like that. Ronnie O'Neal versus this guy, who did better? Ronnie O'Neal, in my opinion. Ronnie O'Neal. And his was even more brutal. Kristen M96, Law Talk with Mike has covered it in the past week. Awesome. Oh, a lot of Law Talk with Mike has been streaming it live too. Very cool. Very cool. Carrie Stolly, no question, just love and appreciation for you. Thank you, Carrie. Black Boots, what surprises me most is that Brooks did not attempt an affirmative defense route. What would your angle have been on this case? It probably would have been not guilty by reason of insanity, and I would claim temporary insanity because it like doesn't make any sense what he did, and there is no motive really for this, and I think he could have used that to his benefit. But again, while also admitting that factually he did what they're saying he did, but not for the reasons, and he shouldn't be criminally culpable for it. So probably something along that route. But I think he is hitting like the most plausible arguments, right? It wasn't me. I didn't mean to. The car malfunctioned. I was running away from somebody with a knife. There was somebody else in the car. I wasn't driving. Do you think there's a court reporter in his courtroom? I would love to see the transcript when he is muted. I don't think so, but I've never had this happen personally to me where a defendant was kicked to another courtroom during trial. Steph Morris, how long do you think it will take for the jury to come to a decision? Thanks again for the great coverage. Thank you, Steph. I think by Friday, probably on Friday. It depends on when they get it on Wednesday because the judge may save those 30 pages. So there may be another hour of jury instructions on Wednesday. It's going to take them a while to go through. So don't let the fact that it takes a day make you think, oh, wow, maybe it's going to be not guilty. Now, it may also be a lesser included, although I think at this point he is sinking his own ship and the jury may just find intentional homicide. Shauna, can she stop his closing when he starts acting up or saying things that are illegal to say in closing? Yes, she can and probably will stop him. kick him to the other courtroom, probably give him another chance as she's done a million times, and then just use the mute button if he goes wild again. You heard what from who? Betty gets shocked by reacting to the verdict. We'll see. Be kind. What is the legal definition of insanity, though? Not understanding what your actions are or the consequences of your actions at the time they were taking place. It doesn't mean that he's still insane or still incompetent right now. It would be at the time the crime is taking place. Latina. They should stop all this nonsense and ask him what the proper punishment should be for killing 5 adults and 1 8-year-old and injuring 70-ish with multiple surgeries. I mean, this is a good point, Latina. And he's cried for them. He has talked about how horrible it is. He's talked about how he's a God-fearing man with his Bible that he's memorized. Against the Tide, Law Talk with Mike and friends have been streaming it for a week. Emily Baker, when she could the last few days, she's in your chat now, or was. Well, I'm sorry I missed her in the chat if she's gone, but that's so cool. Block Boots 437. Do you always invoke the rule of sequestration? I always do, but that's for witnesses, not for the jury. I just want to make sure. Not that you said that. I just want to make sure. Amy Farrell, I'm a Florida girl. FSU or University of Florida couldn't resist very easily FSU. If you go check the behind the scenes, I don't know if I put my diplomas up on there on Instagram at Tragos Law. I did a little behind the scenes tonight before jumping live here. Showed a little bit of my office. There's some FSU stuff in there. Big time FSU. Big FSU guy. Emily D. Baker's not only in the chat, she is reminding viewers to subscribe to your channel. Peter at Lawyer, because she's awesome like that. She's legit. Like, she's legit. No doubt about it. She's really, really legit. Pussycat. Hey, Peter, question. Do you think he would ever be put in Gen Pop, or could he actually spend the rest of his life in solitary? By the way, thank you so much for all the awesome coverage of this insanity. I think he could be put in Gen Pop. I think he could. I don't know that he will. Vinny Pickering, DB trial most popular. What's your plan after this trial? I don't have a plan right now. The plan is there is no plan. Usually what I do is I ask you guys for suggestions, and the subscribers and members of the channel pushed me to Daryl Brooks. I was not planning on covering this case, but the subscribers and everybody pushed for Daryl Brooks. So we made it happen, and now we're hitting it hard. Emily, y'all are so kind. I know he is doing the Q&A. Thank you for being here. Yes, I'm doing my best. They're flooding in. I'm not used to this like you. I don't know how you do this with so many people. You had like hundreds of thousands of people watching during the Depp trial, and somehow you kept it all together. I don't have those kind of skills. Joan Hartley. Why did he say he never waived right to counsel? Because he said he wrote on there that he didn't waive right to assistance of counsel. He just wanted to represent himself. He's trying to make these little arguments that don't make sense. And he doesn't actually ever say he waives any rights, even if, in fact, he does. Tem Exa, how do they exactly gag a defendant? If you want to check that out, I did a video where they did bind and gag a defendant, and we talked about whether or not it actually violated his constitutional rights. So check that out on my channel and get a little deep dive, and you can actually see what that looks like and see what the defendant did. Stephanie Tam, did you know that Brooks was shocked today? I did not know that. I didn't know they actually shocked him. Des, you and Emily should hop on a stream together sometime soon. Both so knowledgeable and quick-witted. I would love nothing more. Andrea Fraley, Emily D. Baker, DM Peter so you two can go on live tomorrow with this trial. That would be cool. DMs are open. Stephanie Tam, just kidding. That's just what I wanted. You got me. Because I am watching on a 2x speed, so I could miss that. Kermit, he clearly did it. The question is if there was intent or not, and temporary insanity would make sense. Kermit gaming profile. I got that. I know. I'm a little slow sometimes with the names. Southern Girl, I think it was premeditated only because he ran over his girlfriend and didn't really get in trouble for that. We need another Fort Brooks, Gregory Taylor says. David Berry, could they sentence him to a maximum security mental health facility if it's not part of the defense? Say hi, the Ashley King for me. Hi, Ashley King. I don't think they're going to do that in this case. Patrick Mott, coming in late to the live broadcast, but great stuff as always. Keep it up. Love your viewpoint into the cases. Thank you so much. Can I get an amen in the chat for Judge Doro? Rebel Duck said. Give her an amen in the chat. AJSA. Sorry, Aja. It's my best guess. I know we've done this before, Aja. Judge said the testifying instruction is only read if the defendant requests it to be read. Is that a normal thing or unique to Wisconsin? I don't know what we're talking about specifically, but I know for a fact the judge will read an instruction that his silence cannot be held against him, whether or not he wants it to happen. Amanda, 3 a.m. in the UK, well worth staying up. Great insight. Thank you for sticking it out. Austin, can DB ask for each juror to announce their verdict individually for all 70 plus charges just to drag out everyone's time? No, they can pull the jury on their verdict. He's not going to be allowed to harass the system and waste time and just annoy the jurors. Zamlot, she cracked a smile when she looked up the first time he put the cardboard boxes up. That was funny. Yeah, she didn't even make him take it down. The DA had to ask the judge to ask the bailiff to take it down. I don't think the judge hated the box for it, if I'm being honest. Labyrinth, Grounds, somebody had to do it. Somebody had to do it in the super chat. Peter, happy to have found your channel. Def will be with you when you cover the next case. Labyrinth, don't just be here. Be part of it. Be part of the solution. Tell me what the next case should be in the chat. Everybody that comes, tell me what's coming up and what you guys are interested in. I love breaking down the trials because it's what I'm passionate about. It's what I do. It's where I live. So definitely let me know what's coming up next. Never Stop Voices. I can go to the courthouse and give you live updates from the media pool room since I'm a journalist if you want. Well, that's cool, Never Stop Voices. We're always down for some inside info. Hit me up on Instagram at Tragos Law and let's talk. Ellen Hood, thank you for the super sticker, as well as John Garner. Okay. Hopefully everybody hit that like button. Hopefully we're hitting that 13,000 like mark. We got Emily Baker's push in here and the surge that she always brings with her. So thank you to all of you that came with Emily and Emily. This was fun. We're pushing towards a live stream tomorrow, potentially. We're going to keep reacting. We're going to keep breaking it down. This trial is not going to end without you all getting my opinion on it. Valo Daybell is definitely happening. Thank you guys so much. Overtime again. Daryl Brooks is making me work overtime too. Thank you guys for joining me. This was a lot of fun. Hit that like button on your way out and let me know. What'd you think? Put it in the comments. I'll see you guys tomorrow at some point.